It's the normal conditions.
I got it back one. Yes. You deserve it.
you're 14, talking about, you're the stupidest person. You get the eye roll, the fuss talks, and all that shit. And then finally they start, because Chris goes, they're not as stupid as I thought they were. And they come back.
She gets 14, 15, 16.
We did. Once I got there, I was in
Okay, we had some. We haven't talked about it.
Right along.
And they get rid of 5 days. Then, after we do this motion, then we will discuss it just like it's. I think the new prosecutors
I agree.
are much more professional than the student position. And it'll be better when it comes to the. I hope it does. I will get the judge to work it out.
We see how that goes. Yes. James, we see how that goes. Now we have to see what we can do. She's living.
Sorry. You gotta get it. Their comments.
You know,
Yeah, I don't want him.
What about 10:30? Can I understand? So, very restricted.
Yeah.
figure this one out.
I'm not trying to buy them.
So you're in for my money.
Yeah, I heard you're building a house in North Carolina. I want to wait it out. That's really mine.
Could be your ass or vacation. Well, we're doing 200 miles.
Morning.
Good afternoon.
You. We're today at least was scheduled and for the motion to dismiss. I have this Trust available to comment. She's required to testify. I'm sure Ms. Bradley is in the building, but I'd like to just adopt their testimony from the hearing that we had on Monday, Tuesday. It would be identical. Basically, probably what I would have hoped to have gotten from talking to the three people that we watched that I can't call. And they went on.
Second, on that problem. I think the misunderstanding was that was, they wanted blind testimony from the motions. They need to leave their questions. Wasn't.
That'd be great. So,
That because.
and we'll discuss it. We'll discuss, we should just, everyone who's going to be the prosecutor case.
Right now, it's like.
Not only for today. That's very dangerous. No final. No final.
I need to know, like, if transfer speeds can go out. I have, for USB.
Some more.
That is on the record, but I'll.
Let's do that. Today should be rather quick.
No, I don't want, I,
Yeah.
no, I want to talk about this next last
So no.
thing, I skipped over, I don't want heated arguments and then we forget.
And then
to
I guess.
So, you guys see this?
And there's been no decision as to who's taking over.
No final decision. It'll very, very, very soon.
I've been asking.
That's fine.
For about 3 weeks now.
My answer is definitely, I recommend. That's fine.
So I need more information.
I'll accommodate
That
whatever way I
with
can.
respect to executive
Whatever you want to say.
I don't know who our prosecutor is.
Have you united front?
He said we're so good. So we got the lawyer. Fire. Somebody
I don't know, understanding this.
said that. I do that several. So I think it's not for you either. It's just like, as a transcript posing. No, I.
Third go around after this.
You could just briefly address the judge, whatever, change the schedule. Not asking you who.
No, you don't. You're not stressed on. I just said if you guys.
All this stuff.
If you want to bring it.
And
I don't know if you're ready to start. I just want to bring it swearing. Bring them back.
We're. No,
We in here, man. We in here, man. See what the fuck they talking about with the boy, Melly. Smelly. Melly's the smelly one. Let's get it.
Thank you. Let's get back on the record, please, and state Florida versus Mr. Dennis. He's present along with his counsel and the assistant state attorney. Do you want to state your appearances?
Daniel Harrison with behalf of Mr. Devens, Stu Adelstein also present, Raymond Liberty, and James Benjamin in back. Mr. Devens is present.
Morning.
Good
Morning, Your Honor.
Good morning, Your Honor. Stephen here in Oakland on behalf of the state of Florida.
All right, so we all set with the proceed. We have a motion to dismiss, I think.
Yeah, that's the last motion I believe we have pending as far as the sets that we have for this week. Your Honor, I think we have an agreement with the state, instead of calling Ms. Boutros again and calling Ms. Bradley again, with the court's agreement, we agreed that we will stipulate their testimony that was taken during the motion to recuse and use that as if it was testimony for this hearing to a motion to dismiss, because it would be identical testimony. It wouldn't be anything different. Yeah, I'm not issue with that.
So it's agreed, that's fine. So regarding the deposition of both Ms. Boutros, excuse me, it's the trial testimony, the hearing testimony, not the deposition.
Right, the hearing testimony.
Of Ms. Boutros and Ms. Bradley. And do you have copies of those? Did you order transfers?
I do not.
I mean, I heard the testimony, I have notes, but I didn't know if you were ordering a transcript.
I'm sure at some time, well, we have not. I did not know until this morning we had this stipulation or anything
Well,
like that.
if there is a stipulation and it's done, is it going to be ordered?
We'll order.
Okay, so then you
And
can
we'll submit it.
submit a copy of the,
Yes.
thank you.
Your Honor, with that said, with that stipulation, we would also now would have been calling State Attorney Pryor, Assistant State Attorney Falk, and Assistant State Attorney Hillary. You have entered your order. We respect your order. We cannot call them. So therefore, we don't have any more witnesses. But I would like to proffer what I believe we would get if, in fact, we were able to call them as witnesses.
Go ahead.
Your Honor, what we believe we would find that if we call them as witnesses is that Ms. Boutros, as she testified to, immediately upon hearing what Detective Moretti solicited to Deputy Gorel, she informed her supervisor, Mr. Killeran. We believe with the testimony would be that Mr. Killeran then went and he talked to the supervisors in the office. My understanding is we will find out that in fact there was a meeting with Ms. Bradley with the supervisors in the office. And when I say that, I believe at times it was just the state attorney and at times it was the state attorney with Ms. Falk also. I don't know which times they were together or separate, but I do know that they were talked to in conjunction with each other and separate. We believe that we would have testimony that they were instructing Ms. Bradley to file the Brady notice. And this goes back as early as basically in October, November, whenever that was, of 2022. The testimony will show that after they did that, pretty much everybody put their head in the sand. They did not check into things. She went through a whole trial. We sat through the trial. Nothing was mentioned about Brady. We find it hard to believe that nobody would have asked her, even after the hung jury, well, how did you handle that Brady issue? What happened with the impeachment of Moretti? Those are things that after a trial are just talked about. But regardless of, we don't know what was talked about, that's what we would try to find out about. We know that even after the hung jury, Brady, as far as what we're talking about, this impeachment material was not provided. And it continued not to be provided until Ms. Boutros took it upon herself to allow the world to know that the state was hiding evidence. Anyhow, you have the three different four Brady notices. You have three different ones as far as the impeachment material goes. And if you notice, one is signed by Ms. Bradley and one by Mr. Killeran. Why we believe the testimony would be that Ms. Bradley refused to sign the Brady notice that was prepared by the supervisors in the office, and she refused to sign it. In fact, it was handed to her by her secretary, and she said, "I'm not signing this," and that's why Mr. Killeran from Public Corruptions had to sign that Brady notice. So she refused the state attorney's basically edict. Then she turned around and she files another subsequent Brady notice. What happens to Ms. Bradley during this entire time? Absolutely nothing from what we know. What we do know is even when we filed a motion to recuse her because of this, the state vehemently has been opposing that. So they didn't sanction her. They buried their heads in the sand as far as what she was doing. They allowed her to do what she was doing after it comes to their attention, after the mistrial, that she's committed a Brady violation. And they tell her to basically get the Brady notice out. She refuses. When they send out one, she changes it and says that's inaccurate. And they do nothing to her except fight to keep her on this case. That's institutional. Then we're here in front of this court, and I said to Ms. Bradley, can we stipulate to the testimony of Ms. Boutros when it comes to the motions to suppress? Or do I have to bring her back the 13, 17 times? And she says, you got to bring her back for each one. That's retaliation. That's retaliation because she had the courage to tell the truth. And that goes to the office of the state attorneys. You put it all together. There was a mistrial. They hid Brady material. Making Mr. Demons go through another trial is a violation of double jeopardy. Jeopardy should have attached because of what occurred. Now, I filed the motion, and I don't want to go through everything in that motion again. I'd like the court to accept that motion as what I would also add it to my argument instead of just being redundant. I believe it automatically is, but I would just like to state that. Anyhow, the bottom line of it is, I've cited to the court Glosson versus State and some other cases. I did not cite to the court one case of this fact situation. Again, I don't know if a case of this fact situation even exists. But Glosson tells us that the actions of the state attorney's office can be such a violation of due process that due process demands a dismissal and not a retrial. And that is what we're saying here to this court, that it's the due process violation, making Mr. Demings go through court, a whole trial where he's facing the death penalty, while the state is holding on to that Brady material. And then even afterwards, it doesn't get revealed until somebody else has the courage to come forward, is institutional. And if the case I cited of Izquierdo, again, not on point, that case deals with the fact that a state attorney apparently had been sanctioned by his office or disciplined by his office before for comments that he made. And then that trial just goes overboard. The case is reversed. It goes back all the way up to the Supreme Court the second time. And what they basically said is that the case can be dismissed. Izquierdo did not put on enough evidence at the trial level when it was remanded. He relied on the original appellate decision, thinking that he was a winner. So the bottom line of it is that if you have institutional, I'm not going to say corruption, but malfeasance, and it's part of that institution, then this court has the power to dismiss. And under these facts, we ask the court to exercise that power, because double jeopardy will be violated if you don't. Okay. Now, Your Honor, I have here statute 838.022. It is a crime in the state of Florida. It is unlawful for a public servant or public contractor to knowingly and intentionally obtain a benefit for any person or to cause unlawful harm to another by A, falsifying or causing another person to falsify any official record or official document. I contend that Detective Moretti was violating this statute.
But we're going to check only outside the four corners of this motion now. I think the argument is not appearing in the motion.
Thank you. Understand your objection. We'll proceed.
C of the same statute, obstructing, delaying, or preventing the communication of information relating to the commission of a felony that directly involves or affects the government entity served by the public servant or public contractor. The state attorney's office itself violated C, obstructing, delaying, or preventing the communication of information relating to the commission of a felony. And that's the felony we're talking about, is what Moretti did. That directly involves or affects the government entity, by the public servant or public contractor.
For the ones working hard so things can keep running, there's Granger. For the ones working hard so things can keep running, there's Granger.
But more than anything, when you look at all this case law on it, it's really the totality of the circumstances. It's not, hey, if you do A, that's bad, if you do B, whatever. If you look at the whole picture, and this whole picture demands that this court exercise its jurisdiction, determine that it was institutional, and dismiss the charges. Thank you.
Thank you. Yes, sir.
Good morning, Judge. First of all, I'd like to state that counsel was giving a proper support. And then that proper sort of merged into the case law and counsel's reasoning. So, but that was just a proper. They don't have that evidence in this hearing, and therefore this court has everything he was arguing about institutional problems in the attorney's office, and there was some charge filed, hiding evidence. All of that is not on the record for the argument for this motion. None of it. They only mentioned what was said in the two testimonies from Bradley and from Ms. Hoover. That indicated that the office of the state attorney told them to tell the truth. Told them to let Boudreaux testify, or let the talk to the defense. And there was no indication of hiding of evidence. There was no indication of institutional obstruction of justice within the state attorney's office. There was no evidence at all that the prosecutors were told by administration to do something illegal or to be told to hide anything. That was all a proffer he would do, and then he uses the proffer to say, okay, well, under the law, there's nothing here that would allow the court to dismiss the case or dismiss the indictment. The normal remedy for a violation is trial. Of course, here that's not an issue. He is getting, the defendant is getting into trial, and they are aware of the statements that were made by Detective Moretti, and therefore there's still prejudice going into the trial. I want the court to know I'm being very respectful of your orders yesterday. I just have to make a record for the state since we're going back to talking about Brady evidence and materiality in this motion. I'm not trying to underline the court wrote. I'm just making a record on the part of the state, which kind of is mentioned in the court's order yesterday on granting the refusal to plan. And as the court states, the state has been arguing that this is a collateral issue, that at least the investigation and the Boudreaux and Detective Moretti were conducting when the cell phone from this came, and he made the statement asking the Deputy Morel to say that he was there at the time of the seizure. We still maintain that it's a collateral issue. To a degree, I think maybe the court is at a slight disadvantage because the court has only heard maybe people talking about that investigation and doesn't really know the substance of it. And the state would be more than glad to.
I'm going to object. I think we're getting into a rehearing on your ruling, not on.
Excuse me. This is counsel's opportunity to respond to the argument. Let them respond to it. But again, both the state and defense could call any witnesses they want at the hearing. Detective Moretti wasn't a witness who was called by anybody, so I really don't know what Detective Moretti would say if called on the stand.
Just pride is that.
So
We said y'all both could have called him up there, but y'all chose not to.
The statement suggested that the court would like the court to do a in-camera inspection of the investigation itself. And that would allow the court to look over the investigation, be aware of all the factors when looking at the issue of whether or not that's a collateral investigation or not. So the state is offering to the court to provide that investigation to the court for an in-camera inspection to help the court.
What investigation are you talking about? The Miramar?
The investigation into the tampering that ASA Mr. Boudreaux and Detective Moretti were in the room that day and making the statement from the scene.
Who was doing this investigation?
The investigation was being handled by the state attorney's office and by Mr. Boudreaux, who was handling the investigation along with the Detective.
Not the Miramar investigation. I was told, and I thought it came up in the hearing that there was some type of internal affairs investigation that was done by the city of Miramar.
It was later on, yes, sir, a year later.
I just wanted to clarify what investigation you were talking about.
I'm sorry, no, this is the investigation that Ms. Boudreaux and was conducting at that time into witness tampering. And that was just with Detective Moretti. They were there to take a statement. Ms. King, her attorney, was there, Mr. Bracken, and that statement was supposedly made. That investigation.
Thank you. Go ahead.
So, again, now, Judge, I am going to reiterate the state argument.
I have to object. He's even stating, he's reiterating the argument they had on other motions.
Thank you. Bishop. And I'm not trying to rush you. I didn't mean that to.
I'm saying it overlaps, so it's hard because in this motion, the defense says at the very end, and that's the third prong of Brady. And the third prong of Brady is materiality. And to start, I can't answer the motion without talking about materiality, whether the statement was material. It has to be material to the case, right? So collateral issues don't fall under that. It's material to the case. If we're looking to determine whether a Brady violation occurs. So when you start with that, the statement must be, we know, evidence, the statement must be relevant, right? It must apply to a matter of issue and not just immaterial. And the state's argument has been impermissible state impeachment evidence based on a collateral issue. That is why we're going to the inspection. Because the statistical investigation is not part of the homicide in the way they perform the fact of the homicide. So, again, it's not collateral. But the first argument, second argument being that when you get to the issue of credibility of the statement, you're bringing in witnesses, right? Are testifying to something that they weren't party to. Wasn't there. So for testimony, she was coming in testifying for collateral issue where she was not even a witness to the initial incident. So it's not great in the sense that that material is not reasonably probable to cause a different outcome in the trial. That is the main point. That is what they look at. They say, well, you have to look at the evidence. That evidence is going to make a difference in the outcome. And in this case, when you go to the first argument is collateral evidence, and then you say you're going to have the witnesses come in and they're going to be given impeachment. Well, if the detective maintains the statement and they want to call Ms. Boutros to counter that. That is not permissible in the sense that now they're commenting or trying to impeach the witness, the detective, with evidence that of a prior bad act. And you cannot do that. You can only impeach with character. If character evidence is not truthful, you're going to bring in witnesses to show that he's not truthful. That's permissible. But it's not permissible to impeach the detective with a prior bad act. Now, I'm aware of the court in its order on accusing Ms. Bradley, argues that it was material, that the execution of search warrant material falls within the exception to the collateral impeachment. So the court basically was saying there's an exception, and where there's any doubt that we might have bias or motive. But again, I understand that the exception, but in this instance, there's no possible bias in the sense that there's nothing pending against this, that there's no charges pending against him, there's no reason for him to come in to lie. So it becomes a little difficult when you think, okay, there's an exception to the collateral impeachment rules, but even though the exceptions, bias or motive to exaggerate, and I'm quoting from your order, or even fabricate his or her testimony, the defendant has the right to explore that bias or motive before the jury, but there's no indication that there was any bias or any motive. There's no charges against him. There's nothing. And you don't know, like you said, you haven't heard from him, you don't even know what his response would be, but he was called and asked whether he said a statement. And that even gets into another issue. He said, yes, I said it. Well, then what? Then you have to be a definitive mind in the world. If they want to call anybody, they got what they wanted. I mean, you better call, you can't call it, Boutros, because she's going to get consistent testimony. And for them to call Ms. Bradley at that point to what? To question what they found, what they wanted. They got, the officers gave them what they wanted, and he made that statement about asking the other officers a lot. That doesn't make any sense. If he comes in and saying, hey, I didn't say it, I'm not, never said it. Well, at that point, they're going to, bring this Boutros in and say the opposite. But to bring Ms. Bradley in, would just say, if there would be consistent statements, but she used them to say, be consistent with that. So we have those issues, but then I agree that, because there is an exception that the court cited in its order yesterday, but I don't see how, they're going to be able to discredit the witness through bias or lack of competency when there's nothing pending. There's no reason for him to come in and lie. I would say to the court, there's a lot of arguments were made in the state memorandum of law filed Monday in support of an order denying the defendant's motion to use the state attorney's office. Those arguments apply here because they're looking at the same thing. And that's why I apologize to you. I don't mean to be going against your order, but I'm just having to renew those arguments because they apply to both cases in the sense that you're looking at whether or not it's great yet. And so I would ask to adopt this legal reasoning that's found in the state memorandum of law for an order denying defendant's motion to use into these motions, the arguments of the state on the motion to dismiss. And then we offer to the court to take a look at take a proper, give an in-camera inspection of the proper in-camera inspection of the investigation itself, see whether or not the court can make a further determination as to whether that's collateral to the issue, because that's the first step in bringing these kinds of material to this case. And when you have another case, it doesn't work. The defense is going a step further, getting a proffer, trying to take destruction in the attorney's office, hiding things. And again, none of that was shown in the court. Now, that's not part of the record. So the court made a reasonable ruling on the motion to quash. They're not testifying. Therefore, they have the testimony of the Boutros and the testimony of Ms. Bradley, and that's served because of
This judge don't give a fuck. Look at him. He like, bro, just carry on what the fuck you read.
Institutional issue with the state attorney's office itself. The court made such a profit. For the most part, never said there was even prosecutorial misconduct. So to get to a due process violation that would require dismissal of the indictment, they don't have the evidence for that, and therefore the court must dismiss or deny the motion to dismiss the indictment. Thank you.
Your Honor, to the extent that you were going to revisit the Brady issue, I was not prepared to argue that today. I didn't think that's what was on for today. And if you are going to be reconsidering that issue, I certainly like the opportunity to address it with case law that I have and the files that I have and whatnot. We think your order as to that issue is exactly on target, and we do not have a problem with it. I do want to point out just one thing that was said, and that is that Detective already getting on the witness stand, and if he acknowledges that he said those things, we can't impeach. So the state is saying that Detective already would get on the witness stand and confess to a third-degree felony and probably some misdemeanors. As that's part of their argument. You know what? If it turns out that way, that he's willing to confess to a crime on the witness stand, we'll live with it. Other than that, I stand by my argument.
Thank you. So, counsel, I'll defer ruling paper under advisement. State asked and offered an in-camera inspection of Ms. Boutros' state attorney investigation. Any objection to that?
Your Honor, yes, because we know that a lot of the stuff was verbal comments that were made, and I don't know how the court gets those verbal comments that were made to each other and whatnot. So I think you're only getting half the picture.
I'm going to talk about that. As far as the transcripts, of both Ms. Bradley, the testimony, not the trial testimony they give. You need a minute? Sorry, no, take your time. You need a minute?
That boy look nervous.
Then for the transcript, address the transcript.
He was nervous as fuck. Because, you know, the judge is not playing. He's like, man, this nigga is playing hardball.
Already?
Your Honor, I think it's important to just note the sequence of events as far as Detective Moretti. Detective Moretti's statement occurred after the seizing of the phone from Ms. King, after the search warrant and whatnot. It's all part and parcel to this case, as the court has found. Bottom line of it, Your Honor, is we just stand by our motion.
Thank you. Ms. Liberty wanted to chime in. I was asking you about the transcript, because you're saying that you're relying on the evidence from the trial, hearing testimony from both Ms. Boutros and Ms. Bradley, and I was just inquiring as to when you anticipated having that. Ms. Liberty was chiming in to offer me a suggestion.
So we tried to order the trial transcript. We were quoted $5,000 for the cost of that hearing transcript. I said $5,000 is a little expensive because it's still having them work overtime, getting us the transcripts of the last trial at this point. So we don't have the transcripts, and I think even if I was to order it on a regular order, not rushed, I'm looking at a month.
Thank you. I don't know about that. I don't know how long it takes to be candid with you. I don't keep track of that, but it's, I don't know that you need this overnight or anything. I mean,
No.
we have 30 plus motions to resolve.
And I think you just need it for the record right now.
Right, I took my own notes and things like that.
Yeah, so we'll just order it normal, and then we'll supplement the file.
Is that all right?
That's fine. So,
All right. So, let me switch topics. Who's gonna handle this?
We just received your order yesterday, so they're working on it nonstop. So we'll have somebody.
And again, I don't know what the state's anticipating. I mean, I don't take it as any disrespect or anything like that. Are you anticipating filing something with the higher court to challenge the ruling or not? Or is that something still in discussion or debate? I'm trying to get an idea of where we're going, and what the schedule is going to be like.
There is still some discussion, but as of right now, that's where I'm on.
So you're still in the process of having, trying to find out who the attorney is going to handle the case.
That's correct. And we're close to a decision, but we don't have any stuff that we need for the moment. Issue.
Always welcome. So the issue I have going forward is we started talking about hearings starting on Monday. I mean, some of these motions are in excess of 30, fair enough? I mean, in excess of 30 motions that are outstanding. I know there's 13 motions to suppress, and I need to get them scheduled because we're on a time crunch. So when and where, and I believe, I wasn't present when it happened, but my understanding was Ms. Liberty was trying to find out and get some time for hearings. At least my office was contacted you the other day, and they were asking about when we schedule hearings. I told them we'll talk about it today. I told my secretary to tell Ms. Liberty to talk about it today. I'm trying to get an idea of when we can schedule these hearings so everybody knows so we can get on it. Because there's a lot of them. And I know
Oh,
when
yeah.
Bradley was here, she was
No,
talking
we
about
don't fry that.
some of them, there was issues that were, I don't want to say commingled, but their same testimony might be to resolve those issues, and we could take 3 or 4 of them on the same day, something to that effect. I don't know if those discussions, who's having those discussions, and what scheduling has been agreed to at this point.
I'll answer that for you, Your Honor. Ms. Bradley and I have a failure to communicate, as one of my favorite movies always use that phrase. Bottom line of it is that we did not work out any scheduling orders. In fact, we have a disagreement as to what motions can be heard.
And Judge, also, let's go.
Excuse me, I'm sorry.
I'm sorry.
I don't understand as to when you say what motions can be heard.
Well, I believe Ms. Bradley would contend that some of the motions are moved because they've been heard before or whatever, and I think she would contend that some of them are not going to be heard because they're not going to be introducing that evidence and whatnot. So I don't know which ones state things are right and which ones aren't. Right now, all the ones we filed, we believe are right until we find out otherwise.
And Judge, I spoke to Ms. Bloom, before this hearing started.
Nah, these niggas in the chokehold, man.
Yeah, sorry.
I thought you said blue.
I mumble sometimes, I apologize.
Yeah, they got
So,
Melly
anyway,
and lawyers in the
you know,
chokehold. That's why he looking.
The state's position is we gotta figure out who's gonna be handling the case.
That man know what
And
he
as
doing.
soon as that happens, we'll get with the new prosecutor and try to work out all the logistics. And of course,
Let's read the
you
chat.
know, the side issue is the state listed, I don't know, 20 new witnesses, 22, I was close, that,
I'll be
you know,
into
we have never heard of before, that we need to take depth of.
Was it
So
remove
we're
Murphy?
gonna have to try to schedule in between jury selection and everything else in motion practice. That's that part. So we'll discuss.
Excuse me one second. Do you know who these witnesses are?
No, I know there was new witnesses listed, but I cannot tell you the relation to the case.
This has to do with the new allegations.
I believe it has to do, it may, but I also believe it has to do with the main case.
May I respond, Judge?
I'm just trying to get an idea.
Sure.
I was preparing a motion regarding these depositions because I've been trying to schedule depositions for about 3 weeks. As of yesterday, I finally just laid out number 1, number 2, number 3 to Ms. Bradley who needs to be disclosed. They are not all regarding the new case. Actually, we've seen motions saying nothing about the witness tampering that's going to be brought up in the murder case for Mr. Planger's 2 motions. So we got, I believe, 10 inmates that are testifying about gang activity, which would be after the date of the murder. I don't really think it's relevant, but we have new experts on the case. I did, in an email, ask where are the reports for the experts. I was told she was at the doctor's office and she would get back to me. And said I got your order recusing her. I did try to speak to counsel today. I offered up my Saturdays and Sundays to get these witnesses done. I have 3 of my own motions going specifically to evidence provided in the trial mapping and the pedometer. I have been given a new witness for the pedometer. I'm assuming after I wrote the motion to keep Detective Moretti from testifying, the state added somebody else now to testify about pedometer. I need to depose them immediately.
Thank you. So, when is this decision going to be made as to the attorneys?
Very, very, I'm sure it'll be made by either the end of the day or by Monday.
Well, Monday, we're supposed to start hearings. So assuming we started the hearings on Monday, who's going to be?
So you're right. Well, it may well be, but, I can't really answer after who will be the other. And I also want to, counsel said that in my motion, anything in my motion refers to the investigation and asked you to look at it.
You know, your motions were really clear that none of the evidence from the witness tampering case would be used in the murder case. You wrote it twice in 2 different motions.
Your Honor, if I may, that's something I'm happy to make. The state's motions and memorandums are very clear. This is regarding the witness tampering investigation and the group justice conducting. This has nothing to do with subsequent arrests that were made. And as Mr. Klinger has indicated, this in-camera hearing or in-camera review is for specifically that investigation, which still remains open. And it has nothing to do with the conversations that the counsel has indicated is all verbal. This has nothing to do with the conversations that occurred after the fact, after the statement by Mr. Moretti. This is the actual investigation, the purpose for the subpoena, the purpose for the statement. It's an open investigation. It has nothing to do with the pending charges and the new arrest.
So this is the way, I told you I would defer ruling on that issue as well as the motion to dismiss. I'll let you know, we'll conduct an in-camera inspection of what's going on in this inspection, or excuse me, in that investigation by Ms. Boutros. My concern, I guess, is we're supposed to be in trial now, and I know my order upset the apple cart a little bit, because we don't know who this assistant attorney handling is. The case, but the concern, I guess, is that this speed trial where it's an issue. My understanding is that once the speeding time expires, I think it has already, hasn't. No?
We got reached the verdict on the 21st falls on a Saturday, so on the timing roll, it would be the next Monday, which would be the 23rd.
So you have a better, you looked at this, so you think it expires when?
The 23rd of this month, October 23rd.
All right, so October 23rd of this month. So, and I know there's, certain other caveats that have to happen. Council have, they have 30 motions that they filed recently that the defense team, new additions to the defense team. And there's a lot of motions that need to get heard. I understand all of that, but we all are under the gun, so to speak, because there's speedy trial. My understanding from the defense, they've made perfectly clear they're not asking for continuance. They want to have the motions heard and they want to be able to go to trial. That's the way I understand it. So it's really imperative that I know who's handling the case for the state.
I understand, Your Honor. And again, I think, you brought up the defense team, we wanted to vote with filing motions that should be taken if the defense team in order to comparing to their case. However, I also have another solution for the court, if the court doesn't mind me giving one, and that would be Judge Fine picked a jury this week on a capital case. He had 250 jurors coming in next Wednesday. They were reserved for it, but they got the jury this week. Those jurors are in fact available, so the court could go ahead, because this prejudice the state in the sense that we now have to bring a prosecutor on the case. And the prosecutor has to get ready. And in order not to prejudice the victims' families and the state and the people of the state of Florida, you could bring a panel in on Wednesday, swear them, and have them come back later on, or after the holiday. And then that gives the trial, all of these motions could be set and depositions, could all be set within a reasonable time period, and then the jurors are coming back without any other issues with the, and you could be heard, with everybody having a chance to be prepared.
Understood, and I don't disagree with anything you said, but that doesn't mean that's the way it's going to happen. It's a distinct possibility, but it's also, assuming that if this defense intends on filing a notice of expiration on the 23rd is the date, is that right?
Yes, and that's why we go to the 21st. Okay.
The 23rd, they would have to file a notice on the 24th.
So if they intend to file their notice on the 24th, I intend to start the trial. And, no disrespect to defense counsel, these motions and depositions are going to be put to the side, so to speak. We're going to go forward on the trial. That's what you want. That's what we'll do. If you want to get the motions and the depositions taken care of beforehand, I mean, we're going to go on trial Monday through Thursday. I think that's what Ms. Bradley and you all indicated that you wanted to do on it. You wanted to say Fridays for whatever type of work you were doing. And I said, okay, unless there's some change, I'll find out who the new prosecutor is. We can talk about it, but I thought it would be on Monday, Thursday. Do what you need to do on Friday.
Our conference may be run earlier than the day they're maybe on the 20th.
I'll keep it 20th. Great.
Whatever it is, and you'll know, you'll let me know, but the point is, we're up against time.
And let me ask also for, I appreciate the court as you consider the proposal that I made. And also, I know the court's ruling, and it's those that are ruling on Bradley Price, like trial, and process.
Honor, did Your Honor agree to see these materials, in camera? If,
I don't report, I didn't read it.
oh, take it under advisement. So if in fact you do decide to do that, let us know, and we just ask if you find that it's something that we, can have, and it is discoverable, we'd like a copy as soon as that decision will be made, that's all.
Well, they're telling me it's something about an ongoing investigation, it's still pending, so typically that is not something that would be shared, with the defendant. I don't know what it pertains to specifically, no knowledge of it, but I mean, if it's something that, I don't know.
Sure, and that's why I'm asking is that this began before October of 2022. So if it's still ongoing, you know, if Your Honor notices that there's no activity since October of 22, that maybe there would be more to it than just them categorizing it an ongoing investigation. So that's all I'm suggesting, is that it may be discoverable regardless of how they label it.
Thank you. Anything else? I'll let you know. Again, I don't know if something I want to look at, because if it's an ongoing pending investigation, it's not something I can really share with the defense. I don't like, I never really liked doing that with the candidate, so, it's not something we should share going forward. I don't know what my feeling is, so let me think about it. But I need to know about the attorney, because I need to know when I schedule hearings, and, there's 13 motions to suppress, and I want to get those resolved. I don't know if the witnesses, I assume they're under subpoena for the trial period now, because we're supposed to be starting. This week.
Your Honor, the last time you made that comment, Ms. Bradley was here, and she said because jury selection was going to take so long, that the witnesses were not under subpoena.
So, if that's the case, I don't know if it's the case or not. I don't remember what Ms. Bradley said, but if that's the case, and there's no witnesses under subpoena, how long would it take the state to get witnesses for these motions?
As soon as we know, I didn't say it won't be long, who is going to be handling the case, people apply to defend them the court. And that is why, again, suggestion of taking them through and justifying that would certainly help in the situation, certainly pressure the state in the sense that for a new prosecutor to take over this double homicide, for the death penalty, the state, a lot for a prosecutor that on last minute to be trying to learn and to understand and be able to make an argument on. And that's why we make suggestions to the court, like holding the panel on Wednesday, swearing in, asking them to come back, and then letting the prosecution have the time to prepare for such a large case and complicated motions. And we'll also give the defense time to do their depositions and file whatever motions they, new motions they can file.
Thank you. Anything else to discuss at this point?
I do have, so since we're doing scheduling, I did have one motion that's not a motion to eliminate. It was basically, started off with a motion to compel, which would be my second one, to get the self-map evidence. We did get a new expert, which I listed. My new expert went through the documents and then informed me that all the CDRs that the state has been provided are not what comes from a cellular company. They went even further and pointed out that somebody went into the evidence that's supposed to be direct from the mobile company and put phone numbers, the names, assigned names to phone numbers. So I would ask that hearing be held as soon as possible, because we do have an huge evidence issue that needs to be resolved immediately.
Thank you. Well, I'm not going to get involved in that until I know who the prosecutor is. I need to know who the prosecutor is. So my thought is I'll set a hearing. If you have decisions going to be made, you think today or Monday? Yes. All right. So if I put this on the docket for Tuesday, does that work? You'll know who it is, and somebody's going to have an opportunity to discuss, I guess, whoever's gonna do it's gonna discuss with the defense counsel, about scheduling these motions and which ones are gonna go first and which ones you wanna do and which ones you need testimony on and where the witnesses are, whether they're available, and how long they're gonna be. Because there needs to be some, discussion regarding that with the defense counsel.
I have the bulk of the motions, I've written that I will be happy to coordinate in any way I can with the new statement.
All right, so are we done? Yes?
And just while we're on the record, I do have 4 USBs that were provided by Ms. Bradley to provide text and put that on the record.
Thank you.
Thank you, Your Honor.
Thank you, counsel. Sidebar, please.
Our meeting, the second.
We're adjourned.
Yeah, man. So I think they just booted the lead detective, well, the lead DA, DA Bradley. Court was adjourned. Start sometime next week. He said it's gonna be a speedy trial. They yeah, they're not playing, man. They about to get that boy up out of here, if you ask me. They already know what's going on. Shit. I wish it could be better news, but you know what I'm saying? You gotta be careful what you do out here, man. Can't be out here playing. And you know, they talking about a bunch of broken ends on both ends, but all in all, man, that judge know what he about to do. He ain't about to play around. He about to make an example. They ain't about to lose to no rapper / street nigga. You know what I'm saying? That's to the state of Florida. You know what that look like? You know how many people gonna, I'm telling you, Melly get out, this shit gonna turn up. You know what I'm saying? So judge already know what's going on. He they gonna do what the justice system normally do. But like I said, trial, I think they got like a couple more motion hearings to go through. He said he got the speedy trial, we gotta hurry this up. We on a time crunch. So I think they getting a new DA. But somebody that shit, she probably been coached up already. Like I said, the play in motion, the script being read. They just doing protocol at this point, man. You know what I'm saying? Like I know what the verdict, if you ask me, will go where it's gonna lie. They're not losing. And that's that, man. But appreciate y'all stopping by on this, you know, live episode of that. Unapologetically me, you know. Be easy.